We do get a fair, Clifton, I don't know if Sheila told you, we get a fair number of people from different states, and and we also have a fair following internationally, where we'll get people from Ireland and the UK and different places. So you might want to just touch on it based on Texas law, as opposed to so people understand it may be different. Here's somebody from New Jersey.
Yes. So let me just say, when it comes to this, Medicaid is a federal program, but it is run individually by each state. And so basically the federal side will give guidelines that states must adhere to, but a lot of times with interpretations with certain areas, the state has more flexibility in having their own input into it. And so that means, just from a practical perspective, if I say something works well in the state of Texas, another state may have something similar, or they may have something radically different. And so this is truly for Texas when it comes to Medicaid. Statutes, I'm going to have, you'll see in my slides that I'll have quite a bit of things that are statutory dependent, but it's going to be based upon the Medicaid handbook for the state of Texas. And so do not presume that your state, if you are in a different one, will allow for that. You would have to go and check to see your state's Medicaid handbook for those.
Very, very good. We actually happen to be working on that in the state of California right now for my mother. So and it is very different. But it's that time. So if you're ready, Clifton, if you're ready, Mason, we're ready to go. Well, good morning and welcome, everybody. My name is Marty Mascari. I am a contractor under the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, or ADRC, both of which are under the umbrella of the North Central Texas Council of Governments in the greater Dallas-Fort Worth, Texas area. And we are blessed to have Clifton, is it Coufal?
It's Coufal, but that makes it easier to just go by Clifton.
Coufal?
Yeah.
Wow. Thank you.
It is a Czech name.
There you go. And Mason Mott here to talk to us about nursing home Medicaid today. And but before we get started, I want to go over the CEU requirements, because I know a lot of you that are joining us looking for certificates of attendance or CEUs. So we're providing complimentary CEUs for licensed social workers and licensed professional counselors within the state of Texas. If you have a different license in Texas, or you have a license outside of Texas, you're more than welcome to follow the program, get a certificate, and submit it to your jurisdiction. But just please note that they may or may not take it. It's really up to them. I've had people tell me they've been able to use them, and I've actually had jurisdictions that have reached out to me after the webinars asking for more information to decide whether it meets their criteria. So the rules are the same for all and for the certificates of attendance as well. Today's program is worth 1.5 hours of CEU credits. You must be on for the entire live webinar and the Q&A that follows until the time that we advertise that we would finish, which is 11:30 Central Time today. If we go over, if there's more questions and we happen to go over, you are not required to go past the 11:30. You've met your requirement. You must also complete the Google survey that will follow this. If you want a CEU, if you want any type of certificate. We also ask everyone if you would please complete the survey, because this helps us report back to the funders on the goals and objectives we set forth when we applied for the funding to do these webinars. But please, I will note The Google survey is required for those that looking for any type of certificate. It should pop up as you close out of Zoom today. Zoom should ask you if you would like to take a very short survey, and it's very short, and that takes them to our Google survey. If you don't get it that way, anybody that is on today that logs in will get a follow-up email from me tomorrow.
Sorry.
And that follow-up email will have the link in it as well. Please complete this survey on or before the 3rd of next month, and give us about 4 weeks after that to get those certificates to you. They will be emailed to you. So I'm going to turn it over to Clifton, and it's all yours, buddy.
All right. Well, thank you. So a little bit about myself. I am an accredited VA planning attorney. What that actually means is that I actually have a va.gov email address. And so when I'm representing clients before the VA, I'm able to help them with that. I'm a member of organizations such as the National Academy of Elder Law Attorneys, NALA, as well as founder of the law firm. And my primary focus areas are on VA benefits, Texas Medicaid, and estate planning. So today we're going to chat about some things, kind of as a very basic overview. We'll talk about the MEPD, and MEPD is just Medicaid for the elderly and people with disabilities in the state of Texas. We'll look kind of some of the MEPD programs, look at basic eligibility requirements, looking at assets, income, health, as well as strategies to meet qualifications. And there are a lot of strategies as far as exemptions, assets. It becomes a very complicated process. We will spend quite a bit of time on things like IRAs, because we are still, our guidance on that is not even in the MEPD handbook. It's actually in a PowerPoint slide that was presented back in 2018 at the NALA conference. So there is a lot of things involved with it, but put in a very simple way, MEPD covers 2 major areas, and that's healthcare services and long-term services. For healthcare services, you're typically looking at checkups at the doctor, medicine and vaccines, hospital care, x-rays. And then for long-term services, you're going to look at home care, personal care, nursing home care for helping with mental illnesses, as well as those that have intellectual disabilities. And so for Medicaid, we have pretty much 2 major categories. We have institutional Medicaid, and institutional Medicaid provides comprehensive coverage for long-term care, and it's designed for seniors who require 24-hour skilled nursing care. And that's going to be primarily what we're going to discuss today. We also have what are called Medicaid waivers. And with that, it enables seniors to receive personalized care services in their home or in a community setting. And these programs basically are there to help you avoid institutionalized Medicaid. So as far as institutional nursing home Medicaid, it provides coverage for long-term care, and it is an entitlement program. An entitlement program that means that if someone is eligible, they are guaranteed services as long as they meet all of the requirements. And with that, you're going to have a level of care that is required. It's typically for those that need round-the-clock medical support. And an assessment is done by a healthcare professional. They'll evaluate the individual's medical functional status and come up with basically it's going to be a yes or no answer. So yes, they are qualified for needing round-the-clock care, or no, they do not. For home-based community programs, and this is going to be your Medicaid waivers, typically your Star Plus and the like, this is not an entitlement program. And because it is not in the entitlement program, then that means enrollment depends on available funding and slots. So that means if budget is increased by the state legislature or from the federal side, then you'll have more money for it, which means more individuals and or services available. Or if there's fewer people, or if there's not as much funding, then it really is going to be dependent on that. I can say that like around COVID time, for looking at STAR Plus waivers, we had over a year-long wait period, though right now we're getting into the 2 to 3 month range and sometimes even sooner. So really with Medicaid, STAR Plus, and the like, it depends on state funding with it. As far as the STAR Plus program, it is a Medicaid managed program. It provides coordinated care. And kind of an interesting part of STAR Plus is that it offers various regional plan options. And so that means depending upon what county you're in, there may be multiple plans that can suit your needs. Everything with that is a program that, again, tries to keep you within your home, but each county will have different programs available to it. So someone in Dallas is going to have different program availability than in El Paso or San Antonio or Temple, for that matter. Typically, they're going to be looking at your activities of daily living. And activities of daily living are going to be things like dressing, toileting, transferring, eating, and bathing. Those are your basic ones. And so typically when you're being looked at by a doctor to determine Medicare eligibility, these are the areas that they focus upon and see how well are you able to dress yourself, looking at toileting issues. Same thing, eating, bathing, transferring, moving from one place to another. And based upon these ADLs is where they'll typically say yes or no to nursing home Medicaid services. As far as documents are concerned, typically you're going to have some type of proof of identity. They're going to look at your income. They're going to look at your assets as well as medical records, and that's going to help them determine medical conditions and needs of the individual. Now, as far as income limits are concerned, if you're on the institutional side, $2,901 a month is the income limit. For home and community-based services, it is also $2,901 a month. And for the aged and disabled, this is typically done with SSI. It actually has a lower limit of $967 per month. And these are all numbers as of March of 2025. So further than that, we have what happens if you have greater than $2,901 in income. I'll just say 2,900 makes it easier. So what do you do if you have more than $2,900 in income? Well, the easiest way to do that is to use a QIT, qualified income trust. These are also known as Miller trusts. And basically they're designed for people whose income surpasses the income limits, but still don't have enough funds to cover all of their expenses. And so typically with that, you're looking to see where the applicant's income will exceed in these thresholds. And so let's just say that someone has $3,000 in income each month. Typically, we're going to take one of those sources of income. Let's say they have Social Security and a small pension. We would deposit the amount into the QIT directly. That is used as a copay, paid directly to the facility. This means that their new income is less than $2,900 a month, and that will now be lowering your accountable income and allow you to meet Medicaid's eligibility criteria. And so typically with the QIT, there are some requirements associated with it. Specifically, it's going to have a separate bank account. You're going to have a trustee that's going to be responsible for managing the funds. And after the beneficiary's death, the state has the right to recover any remaining funds to reimburse Medicaid during the beneficiary's care. But for QIT, it has to be irrevocable. It is income only, so you do not put assets in it. At the end of the month, it should have a zero balance because all funds must be spent from the QIT during the month. And so you're going to have a separate account, and the funds will again be recouped after death. But to be honest, with state recovery, this is usually a very, very low dollar amount where it will only be the funds from that month that are left in that for state recovery. So that's usually a tertiary consideration. Let me also very briefly go into aid and attendance. And the reason for that is that aid and attendance is one of the only programs that actually can provide an additional benefit to those that are currently receiving Medicaid. That's an extra $90 a month. But if they are pre-Medicaid, then this can actually be a program that allows them to stay out of a Medicaid bed, possibly indefinitely. And the reason why, if it is a married veteran, for 2025, you could receive up to $33,548 a year, income tax free, to help you with your expenses. As far as qualifications are concerned, you have to have been active duty for at least 90 days, at least one day during a wartime period, and you have to have a better than dishonorable discharge. And as far as wartime services are concerned, these periods span from goes back to War of 1890, World War I, but not many of those veterans around anymore. So instead, it's really focused on World War II, which was December 7th, 1941 through December 31st, 1946. We have the Korean conflict of June 27th, 1950 through January 31st, 1955. I'm going to skip around and say from August the 5th, 1964 through May 7th, 1975, and from August the 2nd, 1990 to present. There are no location requirements with those dates. So if you were in service on January the 31st, 1955, active duty, and you were only stationed in the United States as a trainer, you never left the country, that is no problem for those dates. So you could be able to receive the aid and attendance program even with no leaving the country. However, for the Vietnam era, which is November 1st, 1955 through August 4th, 1964, wartime period is only considered if you are what is called boots on the ground in Vietnam or in the waters surrounding Vietnam. Typically, that means Hanoi Bay. And so if you were in service from 1955 through August the 4th, 1964, it is a requirement that you have been in Vietnam for you to be considered to be during a wartime period. All of the other dates, 41 through 46, 50 through 55, 64 through 75, and 1990 to present, there is no requirement that you be in any specific location. And so typically with that, you're able to receive a pension amount. Like I said, it can be up to $33,500 a year, and they will have its own set of tests for looking at assets, income, looking at what is your activities of daily living, as well as your wartime periods and your service dates. For VA pension, though, VA law 38 USC 5503 states that a veteran is single or is a surviving spouse and eligible for a Medicaid covered nursing home, then the maximum pension benefit is reduced to $90 a month. So that means that they would receive an extra $90 a month, but they would not be qualified for that additional $33,000 per year. Now, this is reduced pension, and what that means, it is not considered income. This would just be a benefit that is allowed to the individual and is $90 a month extra. And so typically with your application for Medicaid, they will ask that you do that is have that as part of the application process. But again, we can get through those, and a lot of times you can actually stay out of a Medicaid bed depending on your circumstances. So let me kind of go now into our spousal impoverishment rules. This applies for married individuals. We're going to look at first the MMMNA, which is the minimum monthly maintenance needs allowance, and this can provide income for the non-applicant spouse, as well as looking at the CSRA, which is the Community Spouse Resource Allowance. And what that does is that looks on the asset side. So the MMMNA is for income, the CSRA is for assets, and we will go over both of those. So first with the MMMNA, Texas uses the maximum federal of $3,948. And what that does is if your spouse's income is under $3,948 a month, then it allows you to transfer part of the income or up to all of the income from the applicant to the community spouse. And the purpose of that $3,948 maximum is to be able to help the community spouse to avoid poverty. So let me also say, had a very quick question on the A&A side. Is that considered to be income and make them ineligible for Medicaid? The answer would be, because it's a statutory requirement that it would fall down to $90 a month, then that would not be considered with that for the Medicaid bed. So they wouldn't be able to get both. But again, the MMMNA can help prevent poverty. And let's just use this as an example, because I think that's a lot easier for people to work with and to understand. So for example, an institutionalized spouse has $5,075 a month in income. A community spouse has just $1,000 a month in income, and this would give them a combined $6,075 a month in income. Now, that $6,075 with the community spouse having only $1,000, they say community spouse cannot survive on $1,000 a month. So they can transfer up to the maximum MMMNA of $3,948. So that allows them to have the 1,000 plus from the spouse $2,948 to reach that $3,948. That $3,948 is a maximum. And hold on just a second. It looks like my video is not doing well. So give me just a second. I'm going to stop it real quick. And start it up. Mason, can you confirm that you can hear me?
I can hear you.
Okay.
And it's doing something with your picture, but it's not. It's doing.
All right, I'm going to actually just cut the video for right now.
Okay.
I apologize for that. Don't know what's going on there, but if you guys can hear me, that's what's most important.
We can hear you.
Okay. So that 3948 is a maximum of combined the community spouses with any additional income. So in this case, the spouse would receive their $1,000 a month income, as well as $2,948 from the institutionalized spouse, giving them a total of $3,948. The co-payment then would be $2,052, which would give you a total of $6,000, as well as having a $75 personal needs allowance. So co-payment of $2,052, spouse would receive $3,948, and a $75 personal needs allowance, also known as a P&A. So what happens in the scenario where the MMMNA is below the maximum? So let's just say that someone has $999 in personal income, and they're the one institutionalized. they have $75 for their P&A, for their personal needs allowance. That means that they would have $924 income available for diversion. That $924 would then be added to the spouse's total gross income, in this case $1,500, to provide a total combined income of $2,424 a month. Now I'm going to use this number again in the near future, so just remember the income available is $2,424 total. If you subtract out the $39.48 spousal allowance, then that means that this person would have a $0 copay with all of that $924 available for diversion to the spouse. And so that $2,424 is significantly below that spousal maximum allowance. So now we get into SPRAs. So a SPRA is a spousal protected resource amount. What this does, it allows community spouse to keep assets while the institutionalized spouse receives Medicaid. And it protects against impoverishment of the at-home spouse. And it's calculated at the time of first continuous institutionalization. And so for purposes today, to make it simple, think about if you are going into a Medicaid bed, then that is the time of first continuous institutionalization. There are exceptions if it is coming from a hospital stay, but for today's purposes, we'll just say getting into a Medicaid bed. So for 2025, we have asset limits. If you are a single person, you have $2,000 in asset limits. If you are married, then you have a combined asset limit of $3,000 where both are applying. Now, if one person is becoming a institutionalized spouse and the other person is not going on to Medicaid, you can have a combined resource allowance of up to $157,920. Now, this is half of the combined resources up to the maximum of $157,920. And we'll get into some examples in just a minute. Now, let me just say that this does not apply to the SPRA expansion, which we'll go into in just a minute. So how do you calculate a SPRA in Texas? Your starting point is 1/2 of the couple's non-exempt assets. So think about cash, investment accounts, things of that nature. You're going to have 1/2 as your starting point. Now we have a minimum SPRA of $30,828 and a maximum of $157,920. So let me just give 3 practical examples of how that works. So let's just say that someone has combined assets, husband and wife, of $20,000. That $20,000 is under the minimum SPRA. So that means that the spouse would be entitled to have the full $20,000 as part of the community spouse proceeds. No issues with that at all. And the same way, if someone has $500,000 in assets, your starting point would be half of the combined. So that would be $250,000, but we have a maximum SPRA of $157,000. So that means that the community spouse would be entitled to keep up to $157,000, not $250,000 of $500,000. So that maximum SPRA is the number, maximum assets that spouse can keep. Minimum SPRA is the minimum. And if someone has $80,000 in assets, then that means that the spouse would be entitled to keep $40,000. So half of couples' non-exempt assets with a minimum and a maximum. So let's talk about SPRA expansion. SPRA's expansion is, you know how I used the example of 24-24, where their combined income is under the 39-48. So for SPRA expansion, you would subtract the community spouse's non-resource producing income, divide it and subtract it from the MMMNA. And that difference is the additional monthly income needed by the community spouse. You would multiply that monthly income by 12, and this creates a yearly income. You then multiply the yearly income by 100, and then you divide it by the interest rate for a 1-year CD. And so just remember with this, that 1-year CD, it can change. And so for my example, I use a 5% CD rate. In the past, you could see it be a 1% CD rate. In the future, it could be different. So if you have a 3948 MMM-NA spousal allowance, you had a combined income of 2424 total income for the spouse, then that means that you could have up to $1,524 as a monthly potential expansion. That monthly potential expansion would be multiplied by 12 to give you $18,288 in the annual income needed by the community spouse. You would multiply that by 100 and then divide by the current 1-year CD rate of 5% to say that $365,600 would be assets that can be diverted to the community spouse. Now, this does not get cut into half as you would with the SPRA minimum and maximum. Instead, that $365,000 can all be diverted to the community spouse. And by statutes, what it does is that is only the assets that is at the time of application. So if someone only has $100,000 in assets at the time of application, then $100,000 can be diverted. If it's more or less, but the $365,600 would be an example of how much the community spouse is allowed to keep from their total combined assets. So let's go into countable assets, because we have both countable and non-countable assets. We have countable assets, that's going to be your bank accounts, your stocks and bonds, your cash, CDs, all of those things. Now, retirement accounts, it can be, and it may not be. And we're going to get into some more complicated rules associated with that. So with retirement account, I will just say maybe. For exempt assets, this is typically going to be your primary residence, subject to an asset limit. You're going to have personal belongings, which is your household. You can have one vehicle used for transportation, as well as burial plots for the applicant and immediate family. So it's an excluded asset for the home. A home is defined as a structure in which a person lives. And this can include a mobile home, houseboat, motorhome, other buildings, and all adjacent land. So there's no, if let's say that you have a farm with 100 acres on it, that 100 acres is exempt as long as that 100 acres is all contiguous. As of 2025, the home equity limit is $713,000 if you're unmarried, or we don't have other exemptions that can apply, and we'll go into those on the next slide. If the property ceases to become the principal place of residence, it is no longer excludable as the home if they do not intend to return to it. So there is a form. It's a very, very important form if you have a house, and that is Form H1245, and that is your statement of intent to return home. If you fill out the form of returning, if your intent to return home, it does not matter if you are ever able to return home. What matters is you have the intent. And as long as you have the intent, then your home would be an excluded asset. As far as the home equity limits are concerned, we have $713,000. If there is a spouse, then that is an exception where that equity limit does not apply. Same thing if there's a child under the age of 21 living in the home, or if there is a disabled person, and it's not just some random person, but is typically your child or living with you. And you are allowed to now have that as your income limit can be, your equity limit can be unlimited as long as it is spouse, child, or disabled child under the age of 65. We also have excluded assets, real property for sale. And so, I just saw a quick question. What address, home address versus nursing home address? So if you have your intent to return home, what matters is where's the documents going to. And so a lot of times it may be at home. It depends on who's caring for you, but that is a question that typically depends on your situation. As far as excluded assets, real property for sale, what means it says by statute is that you have to make reasonable efforts to sell the property. So this isn't something where you have 5 rental houses and you say, you know what, I'm going to put them all up for sale. I just won't sell them. And that means that I can have that as not counted against me as an asset. However, under F 3130, an individual must accept an offer to buy the property that is at least 2/3 of the current market value of the property. And if an offer is rejected, that individual must present evidence that proves that the offer is unreasonable and the individuals continue to make reasonable efforts to sell the property. So typically with real property, if you own it outright, then you're making reasonable efforts to sell it. You have to accept a 2/3 offer of the current fair market value, and it can be really, really difficult for you to say that that is unreasonable. So this is not one of those strategies where you can just take it. Usually this involves where you have an inheritance where 5 kids own a piece of land, it's not divided out, and you trying to sell 20% of something is very difficult for you to be able to do. So you put it up for sale, and unfortunately, not many people are wanting to buy a 20% stake in something that they can't have control over. Also excluded are prepaid burial contracts. And so prepaid burial contract is an irrevocable contract. With that one, it is excluded regardless of the value. If it is a revocable contract, it is countable as an asset to the extent of its refund value. So those of you that have prepaid burial contracts, it is usually a very simple process to ask the preparer of that burial contract to make it an irrevocable contract. That's something that happens, I'll say, on a fairly frequent basis. So they should typically be able to work with that. But if it is simply a revocable burial contract, then its refund value is countable as an asset. Same thing for burial funds. Now, let me just say with burial funds, it's in the same category as life insurance. And so we're going to get into both of those in a little bit. But a burial fund would allow someone to designate up to $1,500 of resources as burial funds. But they need to be liquid resources, separately identifiable, and not combined with any other funds, and specifically designated for burial expenses. So this just can't be money in a bank account. Typically, it's going to be involved a contract of some type. Also, burial spaces are an excluded asset. And burial spaces, though, can be held for the person, the spouse, or any other member of the person's immediate family as an excluded resource, regardless of value. So that's where a family cemetery plot can help with that. Generally, burial space items are going to be your casket, urn, repositories, and immediate family is typically going to include the spouse, minor adult children, stepchildren, adopted children, brothers, sisters, parents, adopted parents, and spouses of those individuals. So that is typically where you're going to have your headstone, your casket, and the spot is excluded as an asset for a burial space beyond the person receiving Medicaid. Same thing for automobiles. You do have one excluded automobile. There is a possibility to exclude a second automobile if it is set up as a special type of vehicle. And so when it comes to, someone asked it, looking at countable and excludable assets, does that only apply to SPRA or does it apply to other programs? Typically with excluded assets, then we're not going to count that. That is an exempt asset, so that doesn't count for your sprawl. So for example, if you have a vehicle worth $30,000, that is your one vehicle. That is not counted as part of your calculations for assets for sprawl purposes. It is possible to have a second vehicle, but usually that is for very specific handicap needs, where if someone has a special vehicle for mobility where it's been modified for a person to be able to use that, then it's possible for them to have an exclusion for a second, but that is not a general practice. Additional automobiles would be counted for current fair market value. They'll take the equity value of it. So if you have a lien against it, they'll take the equity value of it and use that as an asset against you. Same thing when it comes to goods and personal effects. You don't count things such as your TV, your couches, anything used for maintenance and to occupy the premises as a home. However, if you have something that is held for investment purposes, those would count as an asset. So for example, if you buy wall art and you do a $200 picture in a frame, that's not considered to be an investment. But if you have an original Picasso or Monet, then that absolutely would be considered to be an asset held for their value. Same thing for life insurance policies. As I said before, you have that burial account that had a $1,500 limit. Same thing if a total face value of a life insurance policy is $1,500 or less, HHSC does not consider it as a value for life insurance. However, if the face value is greater than $1,500, then the cash surrender value of the policies are considered to be resources. And so a life insurance policy is a resource available only to the owner of the policy, regardless of who it insures. So if, for example, you had a policy on your parents and your parents are in a Medicaid bed, they are not the owner of the policy, they would not have that considered as an asset against them. Same thing if you have access to things. And so this is actually a good segue question about someone asked if you have things put into a family trust, if the assets were transferred more than 5 years previously. So that would be fine. The question then becomes is, do you have access to that family trust? And is that considered to be something that you can touch? And I use the term touch as an easy way for you to say, is this available as an asset or not? Generally speaking, if you can touch it, it is an asset available to you for Medicaid purposes. If you can't touch it, then usually it is not. So if you can touch it, if you can convert it, if it is for your benefit, then it is an asset available to you. That kind of goes into life settlement contracts. So for them to be excluded, a life settlement contract must be irrevocable, needs to be state or federally insured, allow payments for long-term services, medical expenses, and indicate the total amount payable for expenses. And so this is typically going to fall into your payments for if there is issues with making sure, like an LTCI policy. So long-term care insurance, where they are paying on your behalf, you would not have as an asset the entire amount available to you, but that's going to indicate the total payable for expenses and the like. Same thing, vital contracts, usually you're using that to avoid Medicaid, so it's very rarely used for Medicaid purposes. Just a second. Yes. So if someone has a house, the property taxes need to be paid. There is a problem if you can't afford the property tax, other routine maintenance on it. A lot of times it just depends on their scenario as to we're going to have an intent to return home. If there's a spouse involved, then that's usually make things much easier. There are times if you have a house and we're looking to make sure that it's either kept in the family, not kept in the family, if you have minor child under the age of 21 or disabled individual. We'll get into a little bit of that under exclusions, but typically any time that you rent it out, then that rental would count as income and would likely be considered to be a copay. So having a house as a single person, while you can exempt the asset, a lot of times it can be very difficult for making things like insurance and taxes to be paid for. And that goes into some very complex planning sequences. Excluded accounts would be joint bank accounts, but that is only if you're using separate accounts to reflect correct ownership and access. So with a joint bank account, it would be excluded if the Medicaid applicant can prove that they put zero into the account. The most typical example of this would be if someone has their son in the military and that son in the military puts their parents on his bank account as a joint just so that they can have access to it if anything happens and can pay expenses on his behalf. You'd have to show that the Medicaid applicant put zero funds in the account. Otherwise, the default response from HHSC is the account is 100% owned by the applicant. Same thing if you're purchasing excluded assets such as livestock used as part of a trade or business or for home consumption, then that is not counted. So that means your backyard chickens would not be counted as an asset. Otherwise, then it is part of the whether their fair market value is a countable resource. And they also will exclude resources essential to self-support. This gets into a very, I'm going to say, complex and problematic area. And so property that's essential for self-support is excluded. And this typically is going to be limited to assets such as land, building, equipment, supplies, inventory, livestock as needed for the business. However, if it is inside of an LLC, C Corp, S Corp, or other type of business entity, then typically that's considered to be an asset. And so this really is, I'll say, the original intention of this and how it typically works out is dealing with the single farmer or married farmer that they have the farm, the stuff on the farm is excluded, but the income that they can receive from it would count against them and it directly passes to them as income. And that income would then count against them. Same thing for non-business property. If the equity value does not exceed $6,000 and they receive at least a net return of at least 6%, then that is not counted. But as you can see, 6% of $6,000, you're looking at $360 a year. And so this is one of those areas where you can always, I will say this can be a tricky area where you say, I have rental properties, that's a business property, that's excluded. The answer is no. Excluded would also be UTMA accounts. That's Uniform Transfer to Minor Act. And so child must be under the age of 21 at the time the education fund is purchased. The child would have to remain the named beneficiary of the education fund, and the education fund must remain part of the holdings of the UTMA accounts. This is similar to like certain educational savings accounts. I can say UTMA are excluded always. We don't have to worry about that. But for certain savings accounts, there are some stipulations that can allow them to go back to the donator. And so those are not always excluded. UTMA, though, is a very safe way to say they are excluded. Same thing would be for ABLE accounts. That's achieving a better life experience. And those that have a disability, they can establish a tax-free savings account to maintain their HIM standard, health, education, maintenance. And the only thing is that there are typically SSI asset limits for the disabled person. So this is not something that you should do without making sure that the person is going to be able to actually benefit from this. You don't want to put money into an ABLE account, let them have it, and then have them be immediately excluded from all government benefits because of asset limitation. So this is an area that when it comes to ABLE accounts, this is not an area that you should do on your own, and you should have expert guidance to make sure that person is able to actually receive the benefits that they should. Same thing if we're going to convert assets, so conversion of resources or lump sums, a client is allowed to convert one type of property to another, and then the new property may or may not count as a resource depending upon the policy governing that property. So easy example of that is you have $200,000 in the bank, but you're living in an apartment. You then buy a small house for that $200,000. You have converted that lump sum into a new resource. That house is your exempt asset. It is yours. And then from there, you move into a Medicaid facility after a period of time. Well, that 200,000 would not count against you because it has already been converted into a new resource. There is an exception to that, and that's if you're leasing the land or resource rights. And so the income received from that lease is unearned income, but the sale of the resource is part of the person's trade or business. And so the income received on that is self-employment income. Same thing if you are converting, if you receive proceeds from insurance. So for example, you get into a car accident and the insurance cuts you a check for $20,000. That is not counted as a resource as long as that's used to repair or replace that initial excluded resource. So you can't go and keep the $20,000. It has to be used for the replacement or repair. Prepaying for services, expenses, and taxes. This is typically going to be look at determining countable resources before application, not when you're receiving Medicaid, because if you're a single person, you can have no more than $2,000. So prepaying for services, expenses, or taxes is not something that you're doing while you're receiving Medicaid, but as part of some of your planning strategies. Same thing when you're looking at encumbered funds. This is payments for legally owned debts. And that's going to be, for example, you write a check out to your electric company for $200 and you do that on the 30th of the month. They do not cash that check until the 5th of the month. As of the 1st, that is considered to be an encumbered fund. That will not count against you for asset purposes, even though they have not cashed the check yet. And so encumbered funds are things that the funds are coming out, they're in the process of being removed from your bank account, and as long as they're in that process, then they will not be considered to be an asset for that time period. So looking at nursing home facility payments and refunds, Medicaid does allow for someone's family or friends to use personal funds to be paid in addition to the Medicaid rate in order to have a private room. But with this type of thing, if the family or friends pay the difference, you have to consider how it is being paid. And so if the money is being given directly to the individual, they can touch it, it's theirs, and now it's their income. If, on the other hand, they pay the facility directly, then that is not considered as income to the individual because they never touched it. So same thing if there's a prepayment refund, if someone paid for private pay rates and with a facility where they're in a Medicaid pending bed, once Medicaid eligibility is approved, then the excess amount should be refunded for the months that Medicaid eligibility is established. And for if it's an advanced payment, then that needs to be considered to be encumbered funds for the resources test for initial eligibility determination. And so Medicaid, we have a 60-month look-back period. With that, Medicaid is going to review asset transfers of anything within 60 months of application. It's a practical matter. They don't always look back for a full 60 months, but on statute, it is. And there can be penalties for transfers for less than fair market value, and it can then delay Medicaid eligibility for up to a 5-year period. So Medicaid presumes that every gift is for the purpose of qualifying for Medicaid, and the burden of proof is on the applicant to prove that one of the exceptions apply. Now, the penalty amounts, it basically takes the number of months of ineligibility is equal to the total value of assets transferred divided by the average monthly cost in the state at time of application. And as of March 25, that amount is $242.13 per day. So how does that look? So by statute in I-5310, an individual with a current transfer penalty cannot be certified for a waiver program or state center services. So statute says that if you are under a transfer penalty, it cannot begin until the time period, that 60 months, has expired. So if you've transferred assets, you'd remain ineligible for 60 months going forward from each transfer transaction. And that means that if they are trying to get waiver services or the like, they cannot receive services until after that 60-month has expired. However, there is an exception, and that exception is the individual enters an institution and meets all other eligibility criteria, the penalty period would start and continue for the appropriate period of time. So that means if you are in a nursing home bed, then you are able to start that penalty period. However, if you leave the institution and reapply for waiver services, then you could get stuck with the penalty period again, and you would again not be eligible for a waiver services because that can only begin after the penalty period has expired. So if you have the thought process of, I will go into a nursing home bed for 1 month, try to get out of it, you can unfortunately, once you leave the nursing home bed and apply for STAR waiver, then you can get stuck with that penalty period again. So when does the penalty period start? Then it starts on the first day of the month of the medical effective date if the individual meets all other eligibility requirements. In the event of multiple transfers, then you're going to count that all. It's a combined total. So if, let's just say that someone transferred $5,000 in 2023, $5,000 in 2024, that is a $10,000 total transfer penalty. So that means if you divide that out by the $242.13 per day requirement, that's 41.3 days, which rounds to 41 days that they would have to private pay and would not receive Medicaid for those. Payments during a transfer penalty period, this can be the Medicaid will not pay for your long-term services provider. And payments are basically a private arrangement between the recipient and the provider. In these situations, an individual is not owed a refund when the transfer of assets penalty period ends, or so basically, if you're on private pay for a while during that transfer penalty period, you don't get a refund at the end of it. Now, there is an undue hardship exemption, and a person can claim undue hardship when an imposition of a transfer penalty would result in a discharge to the community or inability to obtain necessary medical services. The easy response to that would just say, oh, well, every transfer I made would result in this kind of undue hardship. Now, first, it does not exist when there's an imposition would cause an inconvenience or restrict your lifestyle. But let me just say, generally speaking, undue hardship is extremely hard to establish. As a practical manner, how that typically works is if someone sent funds to a Nigerian prince, that is something that you can say, yes, that was a transfer of $50,000, but this is a hardship case and they received absolutely no benefit from it and it was scammed out of them. Because of that scam, then it's more easy to establish undue hardship. Now, for application purposes, it should always be asserted, but very rarely are you going to receive that exemption unless there was fraud at play. As far as exempt transfers, transfers by guardian, the court may approve a transfer plan to allow the guardian to make gifts in order to qualify for government benefits, but this is a court issue, and that is one that if I would highly suggest you speak to a guardian attorney because this is a court issue. So that's not something that you can do on your own. Guardianship is its own special category. And so just know that that may be potentially be considered an exempt transfer, but that is beyond the scope of today. Same thing if there are nominal amounts. Now, if the total transfer is less than $200 a month, and this is an aggregate. So if you gave $100 to 5 individuals in a month, that's $500. That is more than the $200 of total transfers. But if you say you gave $150 to a charitable organization in December, there's no other transfer transactions, no penalty is developed for that $150 donation. So again, for exempt transfers with a home, you can potentially transfer title to the home. And there's no penalty if you transfer title to the home if you have a spouse who lives in the home. So for example, you could transfer your assets, you can transfer your home from the institutionalized spouse to the community spouse. That is an exempt transfer. Same thing if it's a minor child under the age of 21 or a child who is disabled. If there is a sibling who has an equity interest in the home and has lived there at least a year before institutionalization, or a son or daughter who has lived in the home at least 2 years before institutionalization. And you can have an exempt transfer to anyone if the deed is either what we call a ladybird deed, which is an enhanced life estate deed, or a TOD, which is a transfer on death deed. Now, for exempt transfers for things other than the home, it looks for the sole benefit to determine who it belongs to. And so if it was for the sole benefit, there must be a written instrument of transfer, or there can be no exemption from the penalty. So typically this is going to be the transfer to the spouse, child under the age of 21 or disabled. You need to have something, and typically that's going to be looking like a trust document. You would transfer, if you can show that a transfer was completed exclusively for other purposes, not to qualify for Medicaid, then that can be an exempt transfer. But remember, the presumption for Medicaid is it was done as a transfer for the purpose of qualification for Medicaid, so that one's a hard one to overcome. Same thing if it's to reflect correct ownership and access to funds, such as the joint bank account, where someone put in 0 funds into the account, that doesn't count. Or if they are purchasing a irrevocable funeral arrangement for the person or their spouse. Same thing, because there is no restrictions on transfers between spouses, which occur from the date of institutionalization to the date of the application. The combined countable resources of the couple are considered for determining eligibility. And so that means that if you transfer items from one to the other, from one spouse to the other, then that's not an issue. Transfer penalties would apply when the community spouse transfers community property before and after institutionalization, if not for the sole benefit of the spouse. So that means when you're making transfers, if you're making transfers to the spouse, there's no problem. But if you're making transfers to the spouse then there can be issues with that for exemptions. Now let me talk about very briefly ladybird deeds versus TODs. Most of those are things that can come up, and so typically, depending upon circumstances, TOD may be a better, or the ladybird may be. I can say with TODs, typically they can have unresolved creditor issues with the estates code. And you can also sometimes get title issues of having to deal with the title company with the TOD that you don't have with ladybirds. Part of the reason is ladybirds have decades of history in the court, and so a lot of things have already been hashed out well. TOD, because it was created by statute, then it doesn't have as much freedom, so you have to look at what the statute says itself. And so with the TOD, it does allow for contingent beneficiaries. That's something that's allowed by statute, which is really great in a favor in a TOD. But nothing in the statute authorized you to transfer property in unequal interest. So if you want to do unequal interest, ladybird deeds are the way to do that. Same thing, it is impossible to use a TOD to transfer property rights with a right of survivorship in the new owner. So you can't do it with a right of survivorship. TODs can also not be signed by a POA. Now, both of them are able to typically bypass MERP, which is Medicaid Estate Recovery Program, which is where they're going against the probate assets to recover for what they've expended out for Medicaid. But since both ladybirds and TODs are not part of it, of the probate, then they bypass it. And both are exempt from the Medicaid 5-year look-back period, since ladybird deeds bypass through Section I-3000, or TODs are under 114 of the Estates Code. The other thing is with the ladybird deed, it can be filed after death. Now, it cannot be signed after death, but it can be filed after death. A TOD, it must be filed before death. So how do you transfer real property without jeopardizing Medicaid eligibility? Typically, you're going to be looking at life estates, remainder interest. You need to determine when the interest was established. And so if it was more than 60 months ago, this is not considered to be a transfer of assets. Less than 60 months ago, then you need to consider a transfer of assets policy. And so can you maintain life estate or remainder interest? Then that's excluded under Section F3000. There can be contract restrictions that prevent someone from disposing of their interest. And again, if the property is for sale, that can be excluded, but remember things with that. Or if the property produces income and it's the small size, then that can be excluded. So generally with property, life estates are the best way to do it, or you look at this from a 60-month time period. You can also do private annuities and promissory notes. And so a non-employment annuity is not a countable resource if it's irrevocable, non-assignable. Payments are in equal amounts during the term, so no balloons. Guaranteed a return of principal during the life expectancy. And the state of Texas is named as first position or second position if there's a community spouse with the private annuity. Now with these, sorry, just a second. Typically, if it's transferable and secured, then it is a negotiable note is a countable resource. If it is non-secure, it is also a community countable resource. But if it is a non-negotiable promissory note and is not a countable resource because there's no marketable value. So now we get into a very fun section when it comes to IRAs. This is a whole fun section of elder law dealing with Medicaid because we are actually dealing with PowerPoint slides. That was back in 2018. Sherry Nichols did this at the NAILA conference. I was there, and it was an absolute shock to see how certain retirement accounts would now be treated. So that's where, when we're basing things upon PowerPoints, know that codified law is not necessarily at play, but instead we can only go by the PowerPoint slide that they're still willing to accept on occasion. So just remember, pension funds are excluded for deeming purposes. Pension monies are held in a retirement plan that's administered by an employer or union or an IRA or co. Now, most 401ks, and you are currently employed, typically this is going to be the non-institutionalized spouse. They are not going to be countable because they're not deemed available due to restrictions on distributions. So for example, if an account It can only be withdrawn upon termination. It is not a countable asset. Same thing, if the account can only be withdrawn with the approval of a plan administrator, it is not accountable. But if there's no restrictions, then it typically is. And so that's where if you have an employment related annuity, and that's going to be basically if it's in an IRA, SEP, or Roth, then you have an annuity described in that with proceeds from that, then that would not considered to be a resource or a transfer of asset. But just remember, name on the check rule applies. So that means if it is made out to institutionalized spouse's name, that's going to be an issue. If it's named into community spouse's name, then you're good. If it's named jointly, then we need to get into the community spouse's name. So this is going to be part of the PowerPoint slides from Sherry Nichols in 2018. And that is assets and tax deferred retirement accounts were counted as resources unless they are invested in deferred annuities. However, she said that in 2018, the policy was modified, and that is where we will actually include copies of the PowerPoint presentation on occasion. Most of them, this has already been 7 years now since we had that PowerPoint presentation. HHSC is pretty well aware of it, but I remember back in the day that was just part of our standard practice of when we're doing a Medicaid application, we're including that PowerPoint slide if the IRAs are involved. So as far as treatment of IRAs, if you're at least 73 and receiving RMDs, required minimum distributions, then the value of the IRA will be excluded as a resource calculation. And so that is where the RMDs would count as income. So before, an IRA would always count in the resource calculation unless it was in a deferred annuity. Now, if you are receiving RMDs, the value of the IRA will be excluded, and this applies both to the applicants and community spouses. And as far as dollar limits, there are no dollar limits associated with that. So how will IRA annuities continue to be treated as exempt assets? And so that's where if there is a retirement related annuity, it is not a countable resource. And so if that is with an annuity described in section 4.8 of the IRC, is purchased with proceeds from basically an IRA, a SEP, or a Roth IRA, then the IRA annuities are not countable. This is what we had focused on prior to 2018. When a Medicaid recipient owns an exempt retirement, how's the amount of income from RMDs determined? And the response back in 2018 was, well, the policy is in the final stage of development and should be issued very soon. And the proposed process to divide RMD income by 12 to determine countable monthly income for eligibility and copayment calculation. Let me just say there is still no statute associated with it, though it has generally been accepted. I can say that as a general rule of thumb, best practice is if you can take out your RMDs in monthly installments to make that part of your copay or the like, that is going to be much, much easier just for calculations because not everyone does things in the best way with that. And so if a Medicaid applicant has already received their RMD for the year, it should apply out over that 12-month period, but it always gets to be a little bit messy when it counts for income, for eligibility, or for copayment. So that's where if you are having to put it into a QIT and you're over for the year and you're doing that 1 month out of 12, then calculations just become confusing for HHSC if they are looking at it. So best practice is to actually take it out 12 months, one time per month, have that going into the QIT if needed, and use that as your copay. Same way if an IRA or other retirement account, if it's inherited, this is after the 2018 presentation, but we're still doing it based upon that. We now have 10-year payout periods, but they're going to look at RMDs, and so it is exempt just as long as you're receiving RMDs associated with it. Same thing if, since RMDs are required at any age, as long as they're taking them out, it is exempt from resource calculation. Now, this is the fun thing that we had happen in 2020, where IRAs got treated as countable because they did not take out any RMDs because the amount of RMDs was $0 for that year. And so we had a lot of battles with the HHSC because no one took out RMDs because it was zero. But I can say going forward, as long as the person is taking out RMDs, the asset is exempt. And if the underlying asset is exempt, then just remember the income it produces is to be treated as countable for determining if a SPRA can be expanded. So because we only talked about IRAs with this, that means your 401k, 403b, 457, SEP IRAs, they are not exempt unless we could get it in through one of the other exemptions that we had available to us. So just like your 401k, if the spouse is still working, it typically will be able to make it exempt. But as a standard practice, if you are retired, all of these accounts are not exempt unless we put them into a deferred annuity. So potential solution would be to take those accounts, roll them into an IRA, but just remember, this can change in the future. That is where PowerPoint presentations are a very poor basis of law, because PowerPoint presentations can be changed at any time by HHSC. So until we get full guidance through the MEPD handbook, this is the likely solution, but I can't say that this will be. It's because we're dealing with areas of law that are not fully fleshed out by statute. It is better to take a more conservative approach with this. And so that's where, would the IRA always, would a 401k always be counted as an exempt asset, or would it be counted as an asset? Sometimes the HHSC may say that it's not, but we cannot say that for certain. So rolling over to an IRA is the most easiest and likely solution for it. Now I'm going to go into very briefly divorce as in order to qualify for Medicaid. Now, Texas has spousal impoverishment requirements for Medicaid. That's where you're going to have your SPRA. That's where you're going to have your MMMNA. And so they have protections that individuals do not when it comes to Medicaid eligibility. And so that means if you are single, if you are now divorced, then you have the strict $2,000 in asset limit applying. And so this can often create more financial problems than solutions. And that is because Texas is a community property state. Texas is one of 9 states that is a community property jurisdiction. In general, that means any property acquired by a couple during their marriage is equally owned by both. And in divorce proceedings, it is likely that the Medicaid spouse will receive substantial assets and then be forced to spend them down to get below the $2,000 before you can qualify for Medicaid. And so as far as needing to wait for that $2,000 for several months before you apply, no, the question is if it was spent down properly, then it's once you hit $2,000 as of the first of the month, 12:01 a.m. as of the first of the month, then that is their date that they look at. And if you're under $2,000 in the assets on that date, you're good to go. If during the month you receive income and it's over $2,900, we'd need to put it into a QIT, make sure that's used as a copay. And at the end of the month, as again, 11:59 p.m. as of the 30th or 31st, then you need to be under your $2,000 limit, because as of the first, 12:01 a.m., they're going to look at it again and say, what is your asset limits? And that is $2,000. So alternatives to that, just remember Medicaid has a 60-month look-back period. If someone has assets, a lot of times you can private pay, and that private pay will basically bring your assets down over time. In order to qualify, you can look at, if assets are already low, you can look at SPRAs to help. And with that, it's always best to look at elder attorneys to determine some best strategies for your specific situation, because there's a lot of variables when it comes to Medicaid. And so kind of as a summary, plan early, understand where your exemptions are. So that's going to be your house, that's going to be your vehicle. You need to document everything. Get clear records. Don't do anything on the back of napkins. Make sure that all your records are clean and clear. And if need be, you can seek professional guidance. We're trying to navigate complex Medicaid rules. Again, pre-planning is always easier than crisis planning, but it's one of those things of with crisis planning, you have to do certain things in certain ways. And so now wanted to kind of open it up to questions, as well as be able to see that this is a lot of information associated with that. And so also want to open it up to Marty if he wants to go on the question side. And in a few minutes, we're going to go on to that next slide for the CEU, I believe.
Yeah, we've got a few minutes. I don't know. Mason, I believe, has been handling most of those, because I have not watched. I've watched them pop up, but they've gone away too. So I'm assuming Mason has answered them. He's keeping up with you.
Oh, that's awesome.
There's one at the very end here.
Mm-hmm.
Do we need to wait until Medicaid? Did you see that one at the bottom?
Yes. I see that right there. So do you need to wait until the Medicaid applicant's balance is below $3,000 for $2,000 for 3 consecutive months before you apply? The answer is no. As soon as you're able to have your assets below the $2,000 limit, you can apply, but just make sure that it is not a transfer and it is actually used for expenses.
Mason, was there any in there that that you answered that you feel like would be appropriate to discuss live while we're still on?
Clifton, you might be able to see those as well if
okay.
If you want to.
Let me kind of go scroll through a few of these. So first one I saw is that if a vet receives aid and attendance, is that benefit considered to be income and make them ineligible for Medicaid? Because by statute, once they are in receiving Medicaid, it drops down to $90 a month, then that is no longer going to be income for them, because it will now be $90 a month. And that $90 would be effectively exempt. That becomes part of their P&As. So they would have $75 plus $90 for their personal expenses. But no, it would not count against them.
We also had quite a few questions just regarding like how the rules for Texas Medicaid, how they compare with Star Plus waiver, for instance, and like income and asset questions. Do you see those?
So yeah, so great question on that. So Star Plus waiver will generally have the same requirements as Medicaid as a nursing home bed. However, there are, because nursing home is an entitlement program, then that means you have immediate eligibility as soon as you're qualified. Star Plus waiver, you have to go onto a waiting list. And so that means it can take anywhere from, like I said, it can be a month up to more than a year. And like I said, a few years ago, we had year-plus long waits for those type of things. And so, but as far as how things work in a practical manner, Star Plus waiver is going to be very substantially similar to Medicaid nursing home bed as far as qualification and exemptions and the like. So yes, there's a question of retirement IRAs are not countable if there are RMD distributions. And so it does not count against you as an asset. However, your RMDs count as income against you, unless they're in a, but if you have other type of what people think of IRAs, and that's going to be your 401k, 403bs, your SUPs, then unless those are either in a deferred annuity or rolled into an IRA, then the asset should typically count. And so when it comes to things like Star Plus waiver, um, it's a little bit more difficult because you're trying to receive benefits in your home. So that means that if you're in a nursing home bed in a facility, they're going to be able to do the diagnosis as far as making sure that you are sick enough to need 24-hour care. And because you need that 24-hour care, it's a very simple process. Medical is not a big part of that. Star Plus waiver, you're going to have to receive a diagnosis to say that you're going to be at a certain level of needing care, and that's going to go through typically the county. And Marty, you may actually be able to speak to some of the options available to those for that.
I actually do not. I put on the webinars, but I have experts that do the under the Area Agency on Aging. So if you have any questions about that, please feel free to respond to the follow-up email that I'm going to send out, and I will forward those questions to the appropriate people and get them answered for you.
Okay. Sorry, Marty, you're in charge of so many different things, and so that's where I know that is one area that the area agency on aging is able to help with that frequently, as well as. And so, but just as far as the process is concerned, I'll give you the very brief process, and that is that you would call. I believe you can call 211 and ask to be put onto the Star Plus waiver wait list. And then you're going to receive, after a period of time, notification that your name came to the top of the list. Like I said, that can be anywhere from weeks, months, years. Right now, we're in the months category instead of the weeks or years, but months, they'll come back and say, hey, you're at the top of the list. Would you like to apply? Then we go through the formal Medicaid application process with that.
You will also find, and we need to get to the CEU slide.
Yes, let me go there right now.
But real quick, if you'll see at the bottom of my emails, there is the phone number for the statewide Area Agency on Aging, more or less hotline, that you put in your zip code, and it will actually transfer your call to the appropriate Area Agency on Aging that serves your area, and they should be able to answer those questions for you with their staff. But I want to go back over the CEUs because we're at that 11:30 point. For those of you joining us today for CEUs, we're providing complimentary CEUs for licensed social workers, licensed professional counselors in the state of Texas. Also, we're providing complimentary certificates of attendance as well. The rules for both are the same. If you have a different license in Texas or a license outside of Texas, you're more than welcome to go through the process, get a certificate, and submit it to your jurisdiction. But please know that they may or may not take it. I have had people tell me they've been able to use them, and I've also had jurisdictions reach out to me for more information on a topic we've done a webinar on to see if it meets their standards. So please note, you're more than welcome to apply, but there's no guarantee. We are set up for the social workers and LPCs in Texas. Today's webinar is worth 1.5 hour CEU credits. You must have attended the entire live webinar. You must complete the Google survey. When you pop out of Zoom today, when you go to close out, it should say, would you like to take a short survey? And it is a very brief survey. You can do it then. And sometimes it won't give you that, depending on maybe your company's computer setup, but you will also receive that link in a follow-up email from me today or tomorrow. And please go to that link. But that's the email that I said before has the statewide Area Agency on Aging numbers on it. The survey will be, the follow-up email will be sent out before the end of the day tomorrow. The Google evaluation, please finish it by the 3rd of April. Give us about 4 weeks to get those certificates out to you. They will be emailed out to you. So look for them in your email. Clifton, I know you tried to play a video earlier on, and I know it did a really odd thing. Not that we need to get into that, because it showed nothing on the screen, but your profile did all sorts of whack. Your profile picture.
I honestly have no idea what was. Let me just turn it on since we're at the end and see if it's.
Well, it's doing the same thing. But if you're interested in getting that out to everybody, if you would send me the link, I will include that in that email if you would like to do that. That's totally up to you.
Well, there wasn't a video per se. That was just me in my office. So
I see.
That unfortunately though, it looks like, I don't know if it's a webcam or a connection to Zoom thing. I've never had issues with it before, but hey, that can sometimes be happening.
I've never seen that. I've never seen that happen before either, so it was odd. So, but I didn't know what you were presenting and whether you felt like it was necessary to do it. But anything that you feel like might be important, you're more than welcome to send that to me today, and I can add that to the email tomorrow if you would like. But though they will get the link to the copy of the slides again tomorrow, and then in about give me 45 days or so, we'll have the video up and available on our YouTube channel, that people will be able to access it, and then I'll send a second follow-up email out to let you know that the video is up there.
Yes. So
anything else?
Oh, looks like, so big shout out to Mason. Thank you so much for Mason is staff member in my office, and so thank you for being able to do some great answers and helping things on the fly. Also, thank you, Marty, for being able to come up and speak to you guys. Hopefully this was informative to you, and now, if nothing else, you know a little bit more about kind of the in-depths of the Medicaid process, because it is a lot of variables that are at play with it.
Clifton, thank you so much. It was really, really, really good information, very informative, and you can see in the chat, very appreciated by many. We haven't done this topic in a long time, and we were overdue. And thank you for stepping in and doing it. We sure appreciate it.
So let me just say, is any other questions that kind of popped up in the last few minutes?
I haven't seen any more. Most of it's just gratitude and people just very appreciative for the information. So if that's the case, then we'll close out. Clifton, thank you. Mason, thank you so much, and thank you everyone for joining us. And y'all have a wonderful day.
Right. Thank you.
Thanks for having us.
Take care.